But here's the bottom line. If you don't know, like if you think about it and you don't know what Aaron Robinson actually said to Kimberly Boyette, then you have a reasonable doubt. How could you possibly know whether or not what he said to her was threatening or intimidating without knowing what it is he said? Was it something as simple as, shh, don't say anything? Is that really a threat? Is that really intimidation? You heard Ms. Boyette, she knew Mr. Robinson. She knew him from picnics and barbecues or whatever it is. Did she really think this kid, this 19-year-old kid, was threatening her when he said, shh, don't say anything? There's the added statement of, I know where you live. And I would remind you that the testimony that we heard was the first time Kimberly Boyette has ever said that is 6 years after the fact. She didn't say that to the police when they interviewed her the first time, or the second time, or when she testified at a deposition, or when she testified at another hearing. This was the first time she said that. So I would submit to you, members of the jury, no, the state has not given you a hamburger bun. They've given you nothing as to element number one. And element number two, that Aaron Robinson did this action with the intent to prevent her from testifying in any kind of proceeding. We heard no evidence about that. No evidence about him trying to keep her from testifying in anywhere. Nothing of the sort. Members of the jury, this should be a simple decision on your part because the state of Florida has not presented you with any evidence for either of the two elements required in tampering with a witness. You now have the instruction on reasonable doubt. And the instruction tells you you can find reasonable doubt in 3 different places. You can find it in the evidence, like Kimberly Boyette's testimony. You can find it in the conflicts of the evidence, like Kimberly Boyette's testimony versus the physical evidence that you have. You can also find it in the lack of evidence. Like, if this was really a burglary and that was a concern for law enforcement, why not collect some DNA from the fence post or the lock? Why not try to collect some fingerprints? Aren't those things important? I'm not asking for any kind of special, thing for law enforcement to come out here and do, like Mr. Diaz was talking about in jury selection. No, these are simple investigation tactics. But they weren't done. In addition to everything that you saw and that you heard from the witnesses here, you also have the statements of Aaron Robinson. Now, the state of Florida wants to try to use those statements to prove to you that Mr. Robinson was some kind of hothead who flew off the handle all the time, couldn't be controlled. But you have the recorded interview. Go back and listen to it. I would encourage you to do that. Because what you're going to find when you do that is what Aaron Robinson says is that he's blacked out when he's been in fights about 4 times, 4 or 5 times, a handful of times. That's it. And Detective Blair's the one that starts talking about a rage monster, and Mr. Robinson just kind of goes along with it. Take the testimony for what it's actually worth, not the exaggerated version of it. Mr. Robinson had a consciousness of guilt? Really? He felt so guilty that he went to his home 1.5 miles away. He felt so guilty that he cooperated with law enforcement, no questions asked. He went down to the district office in the middle of the night without them forcing him to go. That's a conscience of guilt? Yeah, he regretted what he did. That shows a conscience. That's all that shows. He regretted getting into that fight. I bet you that any other day, with the knowledge of knowing what would happen, Mr. Robinson never would have went to the house. This never would have happened. He feels horrible about what happened. That's what his statement tells you. He thinks he's going to prison because he knows he killed a man. He doesn't know the ins and outs of the law. He didn't go to law school like Mr. Diaz and I did. He's walking around the Dollar General with no shoes on, running around with no shirt on, jumping into the back of cabs or beds of trucks. He doesn't know what's going to happen to him. That is not a consciousness of guilt. The reasonable doubt instruction will tell you that you cannot find Mr. Robinson guilty unless you have an abiding conviction of guilt, one that is stable, that does not go back and forth, one that you have no reasonable doubt about. So if you are back there and you find yourself going back and forth thinking, this could have been excusable homicide. This might just be a fist fight that went horribly wrong. Well, then you have reasonable doubt, and the just and right verdict is not guilty on count 1 and count 2. If you're back there and you're thinking, Mr. Robinson was standing in the public right away, he had the right to be there, he was attacked first, maybe he took it a little too far, maybe the fight took him inside the fence line, you have a reasonable doubt. Because remember, the burglary requires intent to go inside the fence line. He had to intentionally do that. Intent to commit a crime inside the fence line. If this fight of mutual combat simply takes him in there, that is not a burglary. That is not guilty. If you find yourself back there thinking to yourself, I'm not sure what I can or cannot believe about Kimberly Boyette's testimony. I don't know what Mr. Robinson said to her. I don't know if he said anything to her. I just don't know. Then you have a reasonable doubt, and I ask that you find Mr. Robinson not guilty. Thank you.